Hi everyone, my name is Justine Ashley and I'm a Master's of Public Policy candidate at the University of Massachusetts at Dartmouth. Educational policy is my area of interest. I've worked in higher ed since I graduated from my undergraduate studies, and in my current role in student affairs, one of my responsibilities is to help students navigate resources on campus, particularly in seeking help academically or emotionally. With this, I've learned the importance of Title IX on college campuses. Thanks to Title IX, women like me have equal opportunity to a college education. In the 1970s, around 59% graduated high school and around 8% had a college degree. In 2010, around 87% of women had a high school education and 28% had a college degree. As you can read here, Title IX of the Education Amendments of 1972 state that no person in the U.S. shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. The essence of this policy is to state that institutions that receive federal funding may not discriminate against a person on the basis of sex. This policy is incredibly similar to Title VI of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race. Title IX was meant to be broadly defined, as it was designed to touch on a plethora of issues. In the 20 years following the implementation of the amendments, Title IX was mainly used to identify a shift needed in female athletic opportunities. Universities were historically unaccommodating to female athletes in terms of facilities and offered far fewer, if any, sports for women. Long after its implementation, cases began to arise where people would argue issues around discriminative employment and sexual harassment or even assault. All of these were in violation of Title IX. As we'll see in the review of literature, the courts often agreed with these plaintiffs and therefore applied a broader scope on Title IX applicability. So even though the Department of Ed is responsible for overseeing the educational amendments and mandates, they've given the Office of Civil Rights the responsibility to enforce these policies. Enforcement of this is done by investigating any complaint reported to the Department of Ed alongside review of randomly selected schools. So when students have a Title IX concern and they've exhausted their options on campus, they can do one of two things. They can sue their institution, which is often a lengthy and expensive process, or as recently noted, they can file a complaint with the Office of Civil Rights to investigate or evaluate the school's effectiveness in reviewing that student's case. In the instances where students have chosen to take their university to court, there have been notable rulings that have shaped future handlings of Title IX investigations. And along with this notable case law, there have been mandates and guidelines set forth from time to time by the Department of Ed themselves, and these have set a base structure for how universities should tackle these concerns around Title IX, and they've also presented strategies for schools to stay in compliance, educate students, and avoid complaints. So as a result of these rulings and guidelines, schools have greatly shifted their processes for investigating Title IX concerns, or at least that's my belief. So with the new Secretary of Education, along with media's recent coverage of sexual harassment issues, I feel that Title IX has been brought to the spotlight once more, and now is a better time than any to review the history of Title IX and try to establish patterns in the timing and effectiveness of these university practices. So my specific research question, and what I would like to investigate, is how has Title IX case law, alongside recommendations and guidelines set forth by the Department of Ed, shaped the university's investigative strategies into sexual harassment complaints? So I feel that this research is important to investigate and would benefit benefit educational policy community, as it would allow us to determine how useful Department of Ed guidelines and court decisions are in establishing processes for universities to mimic, and how specific the language of them should be. So it's my hope that this clarity will help reduce or eliminate mishandlings of cases, and with that there will be a reduction in complaints or universities that are not in compliance with Title IX. There have historically been mandates set forth with potentially vague guidelines. So an example of this, as we all know in the world of educational policy, is the Brown versus Board of Education ruling, which uses the language "with all deliberate speed." So in this case, this ambiguous terminology gives institutions, particularly institutions lacking the desire to implement changes, the freedom to take their time and interpret the language of mandates in their own misguided way. So in cases like this, one can argue that the rulings themselves have set institutions up to fail, and by fail I mean not being compliant. And thus, that creates an arduous burden on the Office of Civil Rights to investigate these schools. I intend to use the results of my research to prove that specific and clear guidelines are more effective than vague up-to-interpretation statements for institutions to use when adjusting to accommodate new policy. So in reviewing the literature on Title IX, I found examples of distinct clarifications for campuses in terms of their investigative strategies or even the nature of the policy itself. So in my research, these are cases I deemed as notably shifting the landscape of Title IX. As I'll explain these shortly, they're valuable rulings worth reviewing for specific suggestions for strategies or how to change your policy on campus. So one example is Pratt versus Indian River Central School District, which was brought forth in 2010. The plaintiff in this case was being harassed for his sex and sexual orientation and attempted to form a gay-straight alliance but was denied permission by administration. The Department of Education helped to clarify for the courts and for K-12 schools as well as universities that Title IX prohibits not only discrimination on the basis of biological sex, but also prohibits discrimination when a student's appearance or behavior do not conform to the stereotypes about how individuals of that gender or sex are supposed to act. And a similar example of this was Doe versus Annika Hennepin School District in 2012. This was a case regarding peer harassment against students who also didn't conform to gender stereotypes. So the Department of Ed worked with this district to improve investigations, enhance training for school staff on how to prevent and respond to peer harassment. And the most notable, in my opinion, is the Dear Colleague letter that the Department of Ed published in 2011. This letter provided schools with specific guidance regarding student-on-student sexual violence. It enforced the importance of the school's independent responsibility to investigate and address concerns. It gave examples of remedies and enforcement strategies that schools and the Office of Civil Rights can use to respond to sexual violence, and it outlined proactive efforts that schools can take to prevent sexual violence. And similar to this, the Department of Ed has also created a Title IX legal manual to help schools and universities understand the legal principles of Title IX and clarify procedural requirements. So these cases are all important to review in order to help me answer my research question, which asks how notable rulings and guidelines have helped to shape university investigative strategies into sexual harassment complaints on campus. So let's take a look into my proposed methodology. For this study, my independent variables will be case law, Department of Education mandates, and specific school complaints to the Office of Civil Rights. These are the factors that can change and can serve as points of comparison for me. Pinpointing practices before and after these monumental decisions will help me to prove that these rulings and mandates shape or force implementation of specific strategies. My dependent variable will be the specific strategy used by institutions to investigate Title IX claims. This all comes together to form my initial hypothesis, which is that strategies and processes become transparent and comprehensive following the Dear Colleague letter, which the Department of Ed distributed in 2011. So my preliminary thoughts on research design are as follows. I intend to build a survey that has pointed questions around changes in investigative strategies over time, and this will be distributed to Title IX officers on university campuses. Review of the university websites will give me their framework and process for investigation as it currently stands, but as I mentioned, the survey would look back and identify prior strategies or processes and how those have shifted. And additionally, I would simultaneously research case law over the past 10 years, looking for specific suggestions into the decisions as to how universities should improve their processes on campus. Upon collection of the surveys, I'll review the qualitative results and determine what rulings or letters were most notable in shifting these strategies. With this, I would look for particularly influential wording or phrasing that can be found in case law or mandates as well as in the outline strategy of a campus. So there are naturally limitations to my research. First off, I make the assumption that all Title IX concerns are reported and investigated, and that the issues in Title IX investigations are strictly around the investigative techniques. The Association of American Universities claims that 72 to 95% of incidents go unreported, and that's pretty startling. This tells me that there needs to be a massive improvement in how campuses educate students on how to report and also create a culture where people feel comfortable reporting. So despite this shortcoming in the amount of complaints, I'm still able to move forward and investigate the shifts in strategies for the complaints that do come through. Another limitation is that I'm looking to correlate changes in campus strategies to case law and mandates, while many campuses cannot specifically pinpoint what caused them to reevaluate their processes in the first place. Campus policy is often driven by leadership, board of trustees, and a campus history around a given issue. So schools that have had exposure to Title IX concerns will likely have a strong process in place and will be looking for guidance from the Department of Ed, while schools that have not had a complaint in recent years or ever may not be interested in changing their procedures or feel the pressure to. So in looking at my timeline and resource requirements for this study, I expect a year is enough to allow this research to be completed. My rough estimate of a timeline is presented here. In the first month, I'll develop the survey to distribute to Title IX coordinators at a random selection of institutions. This will require IRB review, so perhaps it will take more than a month, but that is my guesstimate. In months 2 and 3, I'll distribute the survey and begin to build a timeline around notable rulings that I can use as distinguished points in shifts of practice and to review back and look over. In months 4 through 7, I'll compile the results of the survey and compare the university shifts in practice to my timeline. In months 8 to 10, I'll analyze results and determine what specific rulings or mandates were most closely associated to change in processes, practices, and strategies. And in months 11 to 12, I'll write up the results and attempt to publish. So this is a study that requires very few resources, in my opinion. I'll need access to databases, which are usually accessible via university subscription, and the most notable include Gale Academic OneFile, ProQuest Criminal Justice Database, FastCase, and Hein Online. So I'll plan to utilize public databases as well to review open and prior Office of Civil Rights complaints regarding Title IX. So I hope that this review of my proposed study has helped you to better understand Title IX, how I intend to research campus practice in investigating Title IX complaints, and why this is important to the world of educational policy. I believe understanding the importance of Department of Ed recommendations and case law rulings will help us as policy writers to be specific and clear in providing guidelines to the institutions that we expect to comply with these policies. This is something I'm really passionate about, and I hope that you'll feel free to come to me with any questions or concerns about my proposed research. Thank you.